Thing that I've done, Jack Smith has not been able to answer the vast majority of questions about what's in volume 2 of his special counsel report relating to the stolen documents. Now, it's been said that the judicial order that Eileen Cannon imposed will be lifted in February. And so I guess my point of order is, do we intend to bring him back so he can answer questions about volume 2 and about the stolen documents case?
We'll take it under advisement.
Okay. Well, then
we're just see what the court decides to do, frankly.
I got you. Well, then in that event, I've got the signatures of every member on our side who are writing to notify you of our intent to call him to testify in continuation of this hearing to answer all of the unanswered questions about the second half of his work.
That will certainly factor in tremendously when we make our decision.
Okay, because we have a right on the minority day to have a witness, and we will exercise that right.
You're going to call him back again?
Yes.
Wow. Okay.
So, and
we'll see.
Yeah, okay. I'm citing Rule 11, Clause 2J.
We look forward to seeing the letter, and we'll find out. We'll take it all under advisement, as we said. That concludes today's hearing. We thank the witness.
Stop scrolling, because this is the kind of power play that screams cover-up, now exposed. According to today's clip, Trump just rushed toward federal court right after Jack Smith's testimony, and the chaos isn't accidental. They're talking about sealed filings, Volume 2, and a DOJ that allegedly threatens prosecution if Smith says the wrong word. Think about that. The truth gets muzzled, while the people who wrote the rules claim privilege to bury it forever. That's not transparency. It's betrayal of democracy, and it reeks of collapse. So what did Smith hint at that triggered this meltdown? And what are they terrified you'll see next? The United States agrees that Volume 2 should not be released outside of the Department of Justice. Okay, pause right there. That line is the plot.
100%, Bannon. And notice what we're talking about, right? Having foiled through the vagaries of election a case that anyone who's looked at thinks is completely righteous. Really, his conduct is indefensible. The January 6th crimes alleged were more serious, grave as against the Republic, but this is an open and shut case that would maybe well have been tried, notwithstanding the ticking clock, but for Eileen Cannon. Having defeated that, they are trying now, and I think in contrast to every single independent counsel investigation of which I'm aware, to just smother it from history. What is on on one side, the clear, important right of the public to know the possible criminal charges of the then former president. And what's on this side?
Because if this transcript is accurate, we're watching a government office argue that the public should never see a major piece of a special counsel's work about a former president and classified documents. And I'm going to translate what that actually means in normal English, without the legal smoke. Here's what this clip lays out. Special counsel Jack Smith testified before Congress, but he was restricted. According to the transcript, he could answer questions about January 6th, but he could not address what the host calls Volume 2 of his report, tied here to the Mar-a-Lago documents matter, classified records, and obstruction themes. And the way the clip describes it is blunt. The Department of Justice, under Attorney General Pam Bondi, allegedly used the fact that filings were under seal, plus Judge Eileen Cannon's control over those sealed materials, to warn Smith that if he discussed anything about that second volume that wasn't already public, he could be prosecuted. The transcript even claims Smith asked for clearer guidance on what was safe, and DOJ refused to provide it. If you're trying to understand why people are alarmed, it's that combination. A threat paired with vagueness. Don't cross the line, but no one will tell you where the line is. That's how you chill testimony without having to argue your case out loud. Now, quick note, the timeline inside the transcript is a little messy. There are references like longer than a year ago, 2 years ago, alongside a specific December 22nd, 2025 order. I'm not going to pretend the dates are perfectly consistent, but the sequence being described is clear. The question of releasing Volume 2 is tied up in a sealing fight, and the DOJ is now pushing for it to stay locked away. So what is Volume 2 in this account?
You know, everybody is arrayed personally and politically against the truth coming out. But just to review the bidding, by the way, how about that Jim Jordan? Oh, we'll take that under advisement with that shit-eating grin, meaning like, screw you, Jamie Raskin. But I just want to put a finer point on what you said, Ben, because here's what happened. The case ended. It was dismissed as against Trump, but there was this extant order under Rule 6. You've got to keep grand jury material safe while a case is pending. And she just froze it for a year, has done nothing. Finally, as you say, she got spurred to do it. And what did she do then? Invited Donald Trump, who's no longer a party, and the DOJ is a party. Can you get your mind around this? What are they doing here? They're the prosecutors. They're the one who brought the case. That's the reason that they are parties to this case. And then Nauda and De Oliveira, the potential defendants, and that's going nowhere. So it's just a really...
The transcript frames it as the section of Jack Smith's report about the Mar-a-Lago documents case, described here as Donald Trump taking classified documents, keeping them at Mar-a-Lago, and obstructing justice. The host claims Judge Cannon kept under seal filings connected to that material and delayed action, then set a briefing schedule after pressure from the 11th Circuit. That's the mechanism story: sealed filings, delayed decisions, briefing schedules. But the pressure point, the thing that makes this feel like a democratic emergency, is what the DOJ is arguing now. The transcript reads from a filing titled United States Response to December 22, 2025 Order, and the key lines quoted are extraordinary. The filing, as read here, says the United States agrees with the defendants that Volume 2 should not be released outside DOJ. It also attacks Smith's investigation, calling it unlawful from its inception, accusing him of weaponizing the department, and claiming he targeted constitutionally protected activity. Then the filing, as presented in this clip, leans on a specific concept: deliberative communications. In plain terms, that's the idea that internal government discussions can be privileged. It's a real category in law. But here's why this transcript treats it as a red flag. They're not describing a narrow protection of sensitive details. They're describing an attempt to brand an entire volume as privileged forever. And the guest in the transcript, Harry Littman, makes a key argument. Deliberative process privilege is typically qualified, meaning it can give way when the public interest is strong enough. In this telling, the public interest is obvious, because the conduct described involves classified documents and a former president. So you end up with a clash that's bigger than one filing. It becomes a fight over who gets to know what the government found. Now, the congressional scene matters because it shows how the sealing dispute spills into oversight. The transcript includes Congressman Jamie Raskin saying Smith has not been able to answer the vast majority of questions about what's in Volume 2. Raskin asks whether the committee intends to bring Smith back once the judicial order is lifted. He mentions February as a possibility in this account. And he signals Democrats will use minority rights to call a witness day, citing a rule in the hearing. And the chair's response, as shown here, is basically, we'll take it under advisement.
Crass and completely transparent account from the same people. Donald Trump yesterday at Davos was protesting his innocence of one of the charges, and they again and again, the official position of the Department of Justice before Judge Cannon was that this is completely illegitimate and the whole thing was, total ultra vires. That's like a bad joke for anyone who knows the case. They may be referring to the complete crazy-ass ruling by Eileen Cannon saying there was something flawed about Smith's holding, but about Smith's appointment. But nobody who's looked at has been able to challenge the merits of the case at all. Now, so they come in and basically say the people of the United States should never know the facts of what happened. As you say, at his previous testimony, DOJ, how do you like this, said, remember, if you say a word about this, we're going to prosecute you. And they're looking to prosecute him no matter what.
That exchange is not just political theater. In this transcript, it's the sound of two systems colliding: Congress trying to question, and a sealed court process limiting what the witness can say. Now, zoom in on the second explosive element of the clip, the alleged prosecutorial threat. The host says DOJ told Smith, if you talk about something sealed, we'll prosecute you. Then, according to this account, Smith asked, Fine, tell me specifically what's sealed and what isn't. And DOJ refused. You're on your own. Even if you strip away all the commentary, that structure, threat plus no guidance, is what creates fear, because it forces the witness to self-censor beyond what the law might actually require. It turns testimony into a minefield. Okay, but some people will say, if the case was dismissed, why does any of this matter? Because this isn't only about whether someone gets convicted, it's about the record. It's about whether the public is allowed to see what its own government uncovered. And the transcript argues something even more unsettling. Once the DOJ adopts the defendant's position, don't release it, the normal system of checks can stall out. Lippman and the host start talking about standing and appeals. The point they make is structural. Courts usually resolve disputes brought by adversaries. Someone has to file a motion. Someone has to appeal. An appellate court generally doesn't jump in on its own. So here's the trap as described in the transcript. If DOJ is the party that could appeal a secrecy decision, but DOJ is also the party asking for secrecy, then who forces review? Who pushes the case up to the 11th Circuit? Who keeps it from becoming a permanent blackout? Lippman uses the term collusive lawsuit and explains it as a situation where the supposed opposing sides are functionally aligned. The host translates it into a civic problem. The system expects two teams. If the prosecution becomes the defense, the design breaks. The transcript even gives an analogy, without naming details, about the former New York mayor scenario, where prosecutors decide not to pursue a case and the judge can't simply become the prosecutor. The point in this clip is that judges have limits. They can't replace the executive branch. And appellate courts have limits. They generally need a live dispute and a party to bring it. That's why the clip treats this as more than legal wrangling. It's a governance vulnerability.
And he said, okay, give me guidance what not to say. Sorry, you're on your own. These are just sheer, antagonists looking to, he and Jim Jordan and Eileen Cannon, they're all arrayed against him. I just want to note the so-called deliberative process privilege, and that's what they're saying. Unlike any other special counsel report ever, somehow this is just about the deliberative process, presumably between Smith and the rest of the department, Merrick Garland. It is, like most of these privileges, a qualified privilege, meaning it gives ground when there is need on the other side. Now, Eileen Cannon is never going to find need on the other side. But then, there's a standing issue, right? Because we're in a collusive situation now where the prosecution has become the defense, and who is going to appeal whatever order she enters to the 11th Circuit. But if and when she does, the fair legal analysis here, in my view, is just not even remotely difficult. You have, on the one hand, basically nothing in terms of the interests of Trump and others in this information not coming out. And on the other hand, a really exigent, this is all we got, right, is what happened? What will the verdict of history be? That's precisely what they are trying to smother.
Now, the transcript also layers in rhetoric, calling Judge Cannon egregiously corrupt, comparing the situation to authoritarian regimes, describing the DOJ as aligned with Trump. Those are opinions and characterizations, but the factual spine the clip relies on is procedural and textual. A hearing where Smith can't answer questions about Volume 2, a filing quoted as opposing public release, and an argument that the material is privileged, deliberative content. This is also where the title energy, Trump rushes to Fed court, shows up in the language of the clip. The transcript doesn't show Trump physically rushing anywhere. It describes DOJ swooping in with a filing and aligning with the defendants. The idea is urgency in legal maneuvering, not necessarily a literal sprint through a courthouse hallway. And the host adds a public stage detail. Trump, yesterday at Davos, protesting innocence of one of the charges, while DOJ takes the position before Judge Cannon that the entire investigation was illegitimate. In this telling, that's part of the message management strategy. Deny publicly, bury the record legally. Now let's talk about weaponization, because the filing excerpt in the transcript uses that word. This is a classic reversal tactic. Paint the investigator as the villain and the subject as the victim. But in this account, the reversal is paired with secrecy. You're told the investigation was corrupt, and then you're told you can't see the underlying volume that would let you judge the claim. That's why Littman calls it Orwellian in the transcript, not as a throwaway insult, but as a description of a method. Control the documents, then control the story about the documents. And there's another detail in the transcript that matters for how DOJ justifies its position. The filing excerpt says current department counsel has only secondhand information about how Smith made redactions for Rule 6e grand jury material. The host claims this is because the people involved were removed, framed here as Trump firing those connected to the investigation, so the current DOJ can't vouch for the redactions. I'm not adding anything to that, I'm just telling you what the clip is arguing. But the effect, as presented, is clear. Uncertainty becomes a reason to withhold, instead of a reason to carefully disclose what can be disclosed. Now, one more zoom out, because the transcript itself zooms out and then comes back.
Any fair-minded analysis of the deliberative process privilege would say, sorry, this now yields. The question is, how will it get to the 11th Circuit to actually review what is going to be a complete, phony baloney and skewed decision on her part? But this idea that it's a deliberative process is, yields exactly as it should. It's totally bogus because they're pretending there's big interests on one side. What would those interests be, by the way, for the Department of Justice? You can see Nauda and de Oliveira saying, well, I just assume all this terrible stuff that I've done not come out in my life. That would be that much. What is the Department of Justice suggesting is the reasons for the justice system and that represents all the people, that this should never see the light of day? It's completely Orwellian, right? But so there's going to be some problem practically defeating this. I'll just say it may be this year by the 11th Circuit. It may be 10 years from now from another attorney general. We will one day see volume 2 of Jack Smith's account. We will one day have a very clear historical exposition that Trump was as guilty as sin, not just simply purloining the documents, but repeatedly obstructing them. But it could be a long time. And in between, the indefatigable campaign of Trump is to I erase what was in front of everybody's eyes, both January 6th and this part where he really doesn't, as you say, have a leg to stand on. So the perniciousness of the Department of Justice, not only corrupting the justice system itself, but the very right of the democracy to know, it's nauseating.
The fear here isn't only about one volume. It's about a pattern. Delay, deflection, and drowning the public in narratives while restricting access to source material. The host mentions Epstein-related transparency disputes and uses intense language about cover-ups. Those are claims and comparisons in the clip, and they're not independently established by the transcript itself, but they show what the host believes the pattern is: an executive branch that treats public information as something to be rationed for political advantage. Whether you accept that framing or not, the democratic principle underneath it is simple. A free society needs access to the record to make informed judgments. If the record is sealed indefinitely, public debate turns into vibes and loyalty tests. And that's where this stops being lawyer talk. Because if government can say, this volume will never be released, it's not just hiding a document, it's telling you something about power, that accountability is optional for the powerful and mandatory for everyone else. Here's the part people miss. Secrecy isn't neutral. Time isn't neutral. A delayed record is a weakened record. The longer something stays hidden, the easier it is to rewrite what happened in people's minds. Littman says in the transcript, we will one day see volume 2, but he also admits it could take a long time, maybe this year, maybe a decade, maybe a future attorney general. That's a prediction inside this conversation, not a guarantee, but it underscores what's at stake, whether democracy can rely on later when the present is being papered over. Now, let's land the line-crossing moment using credible terms.
And there's actually is a name for this, that you teach your law students, a collusive lawsuit. But what that means, really, they're on the same side. There's a way of thinking about it that it should just go away, but it doesn't matter because we would be left with the status quo. Collusive just means that there wouldn't be standing. But that's, forget about these legal highfalutin terms. We are exactly where you say we are. The good guys are the bad guys. The bad guys are the bad guys. And they're arrayed together against whom? The country. The country. Look, if somebody doesn't want to see the facts, they don't have to read volume 2 of the report. But how can you say that this episode that so roiled the country, even if you take the bizarre counterfactual view that Trump was phony, how can you not say that the country deserves the facts of everything its government uncovered? It's untenable, but they don't ever, they don't have to say it. They just have to submit papers in front of Judge Cannon that says, oh yeah, we agree with the defendants here. Never let it see the light of day. This is broader than anti-criminal stuff, as the department is doing. It's broader than Bondi as the anti-DOJ. It is.
The line crossed here, based on the transcript's depiction, is an attempt to bury public understanding through intimidation and procedural suppression. Not intimidation as a vibe, intimidation as a claimed threat of prosecution aimed at limiting what a witness can say, paired with refusal to define safe boundaries. Not suppression as a slogan, suppression as a quoted legal position that the volume should not be released outside DOJ, with the possibility it may never be released ever, as the host alleges. Short sentences, because this is the hinge. A witness shows up. He's fenced in. He asks for clarity. He's denied it. A committee asks for answers. They're postponed. A filing argues the public should not see the report, and the pathway to challenge that may be blocked if the government won't challenge itself. That's how democracies get tired, not with one dramatic coup scene, with the slow narrowing of what citizens are allowed to know. So where does that leave us?
The government as the anti-democracy, trying to, it is as Orwellian as you get, just trying to rewrite and erase and smother the history of, what by any account and any political orientation has to be hugely important public understanding of what the hell the President of the United States did. And to do it, by the way, to on the one hand say, oh, this is deliberative process, and then on the other file the motion and take the official position of the Department of Justice. The whole thing was illegitimate, and basically to trash it and make it seem that all these details that we won't reveal to you, and if you looked at, you could just assess, are somehow themselves unfounded and inauthentic, which is the farthest thing from the truth.
With a choice about what patriotism actually means. In a healthy country, national security isn't a blanket excuse for permanent darkness, and privilege isn't a magic word that turns public oversight into trespassing. If you believe in democracy, you don't fear the facts. You let the public see the record, redacted where truly necessary, so people can judge for themselves. Because the alternative is managed memory. A government that asks you to accept conclusions while denying you the evidence. And that is not civic stability, that's conditioning. The calm truth at the end is this: a democracy can survive disagreement, it can survive scandal, it cannot survive a system that trains the public to stop asking what happened. And if this transcript is even close to what's unfolding, then the fight isn't just over a sealed volume. It's over whether the rule of law is something the powerful can fold up and put in a drawer when it becomes inconvenient.